Did you know that 92% of startups fail within the first 3 years of operation, and most of that is because of avoidable legal mistakes? Yes, those legal oversights are hurting your business. But don't worry, in this video, I'm breaking down the common legal traps that startups, SMEs, and even very new businesses fall into. But more importantly, I'm going to tell you how you, yes, you, can avoid them and set yourself up for success as a startup. Hi, I'm Unoma Grace, a corporate and tech lawyer passionate about helping entrepreneurs and startups build and protect their business, their intellectual property, their technology, and their future. In my 6 years of practice, I have worked with so many entrepreneurs and startups just like yourself, and I have seen how a single misstep, just like skipping contracts, delaying IP protection, or ignoring regulatory compliance, can really affect or even nullify all of the hard work that they have done and all of the resources that they have spent in getting their business to where it is at. So grab your writing materials and let us dive into these mistakes that make startups fail and how you can avoid them. Mistake number 1, not incorporating early or skipping the right business structure. Your business structure is the foundation of your business. It is the umbrella that will carry your products, your services, and every single thing that you want to offer. So don't wait to incorporate or to register your business. You need to incorporate it first before you start to flesh out your idea. Don't skip out on it, because the chances are that when you do register it, the name that you had already started building with is probably already taken, or someone else has copied your business idea, and there is absolutely no way for you to protect yourself, and a whole host of other reasons why you should always incorporate first. Do not make the mistake of waiting or delaying your incorporation until a time in the future. Do it now, do it fast. While it's very important, yes, to incorporate your startup really early on in your journey, but it's almost as important, if not more important, to pick the right business structure. Now, most startups, most entrepreneurs, most freelancers who want to transition into having their own business or developing their own technology in full, the first thing, I need a partnership, I need a sole proprietorship because it's cheaper and it's quicker and it's easier to do. But these business options offer zero liability protection. It's always best and advisable to register as a limited liability company or a limited liability corporation, depending on where you live. Now, the benefits of a limited liability corporation is that, first of all, there's liability protection. Second of all, that entity becomes an artificial person that can sue and be sued in its own name, that can buy properties and sell properties and otherwise engage in transactions as its own person. It endures in perpetuity. That means it lasts forever until maybe it is wound up voluntarily, or you file for bankruptcy, or you transfer ownership, or you sell it, or you otherwise do away with it. But if none of those happen, then it endures in perpetuity. These are just some of the reasons why, first of all, you need to incorporate your business early, and you need to incorporate it under the right structure. Mistake number 2, postponing proper legal advice and DIYing the law. Now, there are a lot of startups and a lot of entrepreneurs and even freelancers and small businesses out there, and I'm talking about you, yes, you, who will think, the law is so expensive, I can't get a lawyer, let me go to Google or ChatGPT, let them spit out this agreement for me or advise me on. That might be cheaper in the short run. That might solve some situations in the short run. But in the long run, it will get you into way more trouble than is worth your time and your effort. Because what then happens is you use ChatGPT to draft the agreements, you use Google to answer your legal questions, and then 2 years down the line, you find out that, wait, this thing ChatGPT did is wrong, and now you pay a lawyer to come and fix your mess, and they charge you more. So it's advisable to just bite the bullet, right? Pay the higher cost upfront, and save yourself years of stress of coming back to fix mistakes that were made in the past. So do not DIY the law. I've seen, in my 6 years of practice, I have seen this happen so many times, that people try to DIY the law and they end up putting themselves into even bigger troubles than they realize. Mistake number 3, neglecting contracts and agreements. If you're one of those people that enjoy working with family and friends, and it's not wrong to work with family and friends at all, but if you're one of those people who enjoy, he said this is a gentleman's word. No, 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 no. Gentleman's word or gentleman's word does not hold up anywhere, least of all in court, least of all when it comes to protecting your legal rights and enforcing the terms of that contract or of that partnership. If you have a business partner, please, 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 by all means, even if it's a business partner, a supplier, a vendor, in whatever capacity you're about to work with someone, always write down your contracts, the terms of your contract. Always write them down. Put it into writing. It saves you a lot. Mistake number 4, not identifying or ignoring intellectual property protection. In today's world, people are way more creative now than they were ever before. That's why it's very important for you to not only identify what your intellectual assets are, but also to protect them. Your intellectual property can range from your software to your products, your hardware products, to your business model and your technical know-how. You can protect these intellectual assets. And as an entrepreneur, as a startup, it's important for you to identify every single intellectual asset that you have. No matter how big or no matter how small you think it is, you need to identify it and take the appropriate steps to protect it. You could protect it through copyright, trade secrets, trademark, or even patents. And the benefits of protecting these things on time is, number 1, you retain the rights, the exclusive rights to it, because for most of these intellectual protections, the first in time always stands, or the first to apply, it always stands. And not only that, you retain the name, you retain the rights to exclusively use, distribute, share, and manipulate that work in whatever way you can. You can also stop infringements on its tracks. And yes, registering or protecting your intellectual assets at the beginning, they might be more expensive. Very true. The valuation of your startup has significantly increased because you have some intellectual properties that are attributed to you. So don't try to skimp out on registering or even identifying your intellectual property. Do that and do it fast. Mistake number 5 is non-compliance with tax and other regulatory laws. Now, yes, taxation, regulatory compliance is overwhelming for anybody. So, I can understand the need for any founder to want to put that off to the back burner and focus on growth. But don't do that. For the sake and the longevity of your startup, do not do that. Focus on taxation. What are the tax incentives that the business structure you have chosen, what are they entitled to? What are the regulations that you need to comply with? You need to know these things from the get-go to even assess whether or not you have the capacity and the capability to launch your startup. Because it's much better to decide and answer these questions at the very beginning than to get into your startup, to start operations, and then you meet an investor and they ask questions about, what's your tax returns? Have you filed your taxes? What are your regulatory compliance requirements? Have you done them? And then for you to look like you have no idea what your investors are talking about. So please, get an expert. It doesn't have to be a lawyer most of the time. There are compliance experts that are not necessarily lawyers. There are tax experts that are not necessarily lawyers, although having a lawyer that has these skills are also very important. But you can outsource them. Get an expert in your jurisdiction, because different countries, different jurisdictions have different laws and different things that apply to them. So get one within your jurisdiction, within your locale, that can help you out and sort these issues. Mistake number 6 is mishandling data privacy and cybersecurity policies and or measures. Now, in our world today, data is practically the new gold. Data is an asset. And if you're in a position, if your business, if your startup is in a position that it deals with data from customers, you need to take that seriously, because there are laws, there are rules in place for handling how you collect, how you assess, how you store, how you use, and how you process your customers' data. So do not think, my data is less than 5 people. We're not handling that much data. No, the law does not make exceptions. as to what kind of data you handle and when. As long as you are collecting people's personal information, even as little as their email address, yes, you need to comply with data privacy and cybersecurity laws. And it's not enough to just have a privacy policy up on your website or a terms and conditions up on your website and think that's about it. No, there are certain other obligations that you, as a data collector or even a data processor, needs to be aware of and needs to comply with. Mistake number 7. Oh my god, this one is a doozy. Mistake number 7, failing to obtain a good title for your intellectual property, especially when it was created or done by someone else. Now, you're a startup, you have employees, and while in the course of building your startup or in the course of operations during your business hours and whatnot, your employee comes up with something new and revolutionary for your business. It doesn't even have to be new or revolutionary. It just can be something that is worth protecting. You need to obtain a good title for that. Who actually owns the intellectual assets that has been developed? Are you the owner, the employer? Do you own it, or does it belong to your employee? Now, if it's in a case of inventions that are protected under a patent, then it's your employee that owns it. Even if they used your Wi-Fi or any other business material or even did it during business hours, it's irrelevant. It's your employee that owns that invention that is protected by patent. And you then need to have that patent or have the use of that technology or of that innovation assigned to you by your employee, and you need to pay your employee a sizable consideration for that. Now, if it's something that is protected under copyright, if it's an intellectual asset that is protected under copyright, then it belongs to you because it's a work for hire. There are certain work for hire protections that are applicable to works that are created by an employee or a contractor, but it has to be by an employee. That's why correctly naming your staff is also very, very, very important, which is another mistake that we will get to. Because if you do not properly name them, there's absolutely no way you're going to figure out how to navigate the intellectual property assignment. So if you have an employee, please properly obtain a good title to your intellectual property. And if you're not sure who owns what and it was created by your employee, the best and the safest option is to draft an assignment, an IP assignment agreement from your employee to you, assigning you the rights to use that intellectual property. And in exchange for that, you will pay them a sizable consideration. Mistake number 8, failing to identify and protect your trade secrets. Now, as I mentioned earlier in one of the mistakes, trade secrets are an intellectual property. And don't say, oh, I have no trade secrets. Yes, you do. Your business model can form as a trade secret if it gives you a competitive advantage in the market. Your technical know-how, your network, that's a trade secret. Who do you know? Your connections, that's a trade secret. Your knowledge is a trade secret. So you need to protect these secrets. And how can you do that? By putting in place agreements, procedures, and policies that tell people that, hey, this information is confidential. Hey, this technique is confidential. Hey, this way of doing business is confidential, and for them to treat it as such, because it ceases to be a trade secret if the whole world knows about it. So it's confidential information and it needs to be treated as such. Mistake number 10, not adopting an appropriate employee stock option plan, an ESOP in short. Employee stock option plans are incentives, equity incentives that startups give their employees to incentivize them to work with the startup for the long haul. It's basically you give them a part of it, a share of your company. You give them shares, you give them equity out of it. Now, the most common mistake I've seen, especially in my home country, Nigeria, founders offer equity to incoming prospective employees for a company that has not even been registered. I mean, make it make sense. Where is the equity coming from? You're basically giving them equity out of thin air. It belongs to no company. And God bless their souls. Most of these prospective employees, they don't know any better. They just hear, "Ooh, I will give you 15% equity for my idea," and you believe it hook, line, and sinker, and you don't ask questions, and you then 2 years down the line, you're wondering, where is this equity? And it's like, oh yeah, you are not included in our incorporation documents. Please don't do that. Dude, if you're a founder, do not ever offer equity to someone for a company that you have not registered yet. That's fraud. That's fraudulent misrepresentation, and you are liable for that. As a prospective employee, please, if someone offers you equity for whatever reasons, make sure that, first of all, it's documented. Second of all, changes are made to the company documents that you can visibly see, to ensure that yes, you actually do own equity in this company. Be 101% sure to avoid heartbreak in the future. That's the very first thing. The second thing is that most founders grant ESOPs off the top of their head. They do not follow the right procedures. They do not follow the right processes to grant these securities. Because when you start to offer securities to prospective employees and current employees, there are laws that guard that. That share percentage becomes restricted from issuance. Right? That's one. Two, that security must be registered. Now, if you're a founder and you don't know any of these and you just go about offering equities because you feel like you have it to offer, this will most likely land you in serious trouble with your investors. Because when investors come in, they are going to be issued more shares. So how do you want to reconcile the shares you've issued to the investors with the shares you've issued to your employees? That's why you need a lawyer to help you document these things and to help you figure out the appropriate ESOP plan for your employees and incoming investors, so that when you get to the fundraising stage, it doesn't become an issue. Now guys, I have given you 10 reasons why startups fail legally and how you can avoid them. But because I'm generous, I'm going to give you an extra 2 bonus reasons why. Selling securities, that's shares and equity, to unaccredited investors, and or not properly structuring your fundraising. Now, fundraising, this is a period when startups are super excited. They're focused on scaling, on growth, and they forget the more boring, in quotes, sides of fundraising, which is about things like, okay, what financial instrument are we going to sell? Is it going to be equity? Is it going to be bonds? Is it going to be debt? Is it going to be convertible notes? Is it going to be, a simple agreement for future equity, which is a safe? Is it going to be a SAFT? What kind of financial instrument are they going to use? What are the anti-money laundering or countering the financing of terrorism policies that they need to use in their business? What are the legalities of fundraising that they need to be aware of? These are the more boring aspects of fundraising, but there are aspects that you need to pay very close and very rapt attention to. Because if you expect that an investor is going to give you his money and then keep quiet, or give you his money and then watch you blunder the company, or that's not going to happen. In this day and age, everyone is focusing on where their money goes and to ensure its growth. You need to pay attention to this, not only to maintain your reputation, but also to ensure your longevity within the market. Because it's one thing to scale, and it's another thing to scale properly and sustainably. And you want to do both. So you need to pay attention to these. And if you cannot personally, as a founder, pay attention to these, then by all means, get you somebody that will. Get you a lawyer that actually knows what he or she is doing, that will pay attention to these boring aspects of fundraising and selling your securities, to ensure that your business scales and grows sustainably. Bonus tip number 2, and that is the mistake of ignoring corporate governance or not even understanding corporate governance. Now, corporate governance are the practices, the procedures, and the rules, the policies that control and direct your company. This involves how you interact with all of the stakeholders in your company. Now, every company, regardless of niche, every startup, regardless of niche, has 4 major stakeholders. They are the government with your government and your legal regulatory compliance. You have the investors because you sell securities to them, they own shares in your company, they basically own your company. You have the customers who are technically in charge of you're making a profit, because if customers do not buy, you do not make a profit. So customers are very important. And your employees, who are the people that run the operations of your company. They are the ones that actually run the day-to-day operations of your company. Corporate governance affects how these stakeholders interact. It affects their relationships, and you need to be on top of it. Corporate governance practices like holding regular board meetings, holding your annual general meeting, filing your annual returns, maintaining proper financial documentation, documenting your processes as a company, your marketing, your growth, your operations, and every single aspect of your business is all under corporate governance. And when you begin your company, it is a startup, but the more you grow, it ceases to be a startup and more a structured corporation. And you need to treat it as such. You need to take care of it from the beginning so that when it grows, again, it grows and it scales sustainably. And so guys, haven't seen these 12 reasons why startups fail legally, or the 12 mistakes that startups make. You can clearly see that these mistakes, they not only cost you time, they also cost you money, they also cost you relationships, sometimes your reputation, and other resources that you have spent in building up your startup to where it is right now. And you do not want to make any of those mistakes. So take the tips that I've given you and religiously follow them to avoid these mistakes and to set yourself up for success. So here's your next move. Subscribe to this channel and put on your notifications, because in the next video, I'm going to give you the ultimate compliance checklist for startups and SMEs, so that right from the get-go, you are ticking off every single compliance requirement that you need to set yourself up for success. Bye guys, until next time.